Thank you for tuning in to today's Navigating Taxes Update. Today's update is designed to educate you on the recent scrutiny and evolving interpretations of Public Law 86272, especially as it relates to businesses with interactive website and digital services. To guide us through these developments, we're joined by Scott Brody, tax principal at Honcamp. Scott leads our state and local tax practice and has more than 25 years of experience advising businesses across industries and navigating complex multi-state tax issues. So Scott, can you break down Public Law 86272 for us and explain why it's becoming such a hot topic for businesses with an online presence?
Sure. Let's start with the basics. Public Law 86272 is a federal statute from 1959 that protects out-of-state businesses from state income tax if their only activity in the state is soliciting orders for tangible personal property, with those orders approved and fulfilled from outside the state. And kind of an interesting side note is that this law, it's really a reflection at the time of how the U.S., what our gross output, if you will, was comprised of. We were doing a lot more manufacturing back there, right? Back then. So it's interesting they carved this law out to protect companies selling tangible personal property alone. Because now, if you think about it, even Honcamp, we're a service company. A lot of businesses it's a service economy these days, it feels like. And so we see companies get pulled in where they otherwise wouldn't have been had they been selling property. So, and to my point, that law was written long before the internet. Now states are reinterpreting what, quote, solicitation means in the digital age. So in 2021, the Multi-State Tax Commission, which is basically an organization that roughly half of the states belong to, and they share thought leadership, and they help each other during audits and issue tax guidance and so on and so forth. And in 21, that commission issued updated guidance that narrowed the scope of protected activities. See, back when this law originally got out there, the MTC did a similar review, but now they've re-upping it for the digital age. And according to the MTC, if your website does more than just display static content, say it offers live chat, post-sale support, or lets users apply for jobs, you might be crossing the line into unprotected territory. So remember where we're at now. In 21, the MTC issued more guidance that said you might be, if your website does certain things, you might have unprotected nexus with us. And so in 25 now, states like New York, California, and New Jersey are starting to take this guidance from the MTC and work it into their own formal regulations. So in New York, for example, they consider activities like placing cookies on user devices for analytics or offering branded credit card applications online as taxable business activities. The New York Supreme Court upheld those regulations, ruling that they don't conflict with federal law. However, the court did strike down the state's attempt to apply the rule proactively back to 2015, citing due process violations, and that's a concern. A lot of times when states try to write new regs in, they always want to take it back to a point in time where you didn't even have a chance, really.
Mm-hmm. So what does this mean for businesses?
Well, if you're selling tangible goods online and relying on PL 86272 for protection, you need to audit your digital footprint. Take a look at your website and your digital activities and ask yourself, does your website offer post-sale support via chat or email, or are you collecting customer data through cookies for marketing or product development? Or can users apply for jobs or submit forms unrelated to sales? And if so, you could have nexus there in states that have these types of interpretations. So we would encourage you to reach out to us. But on the other end of the spectrum, and you kind of see this battle a lot of times with Congress frustrated at the complexity of state and local tax and sales tax because there's so many jurisdictions. There's over 10,000 easily taxing jurisdictions in the U.S. when you consider school boards and school districts and parishes and all this kind of thing. But Congress introduced the Interstate Commerce Simplification Act, which aims to modernize PL 86272 by expanding the definition of solicitation to include digital activities that support sales, even if they serve other business functions. So this would be good because if it is passed, it would restore protections for many online sellers. But until this goes anywhere, and I'm with the state of Congress, I'm not sure what's going to get done these days. But until they act on this, you want to go ahead and review your website and apps for interactive features that go beyond solicitation. Reach out to your tax advisor to determine whether you may have exposure, and keep an eye on legislative developments, especially in the proposed federal amendments. It's no longer a blanket shield, this Public Law 86272, but because in today's digital economy, even a few lines of code can trigger tax obligations. So I would just keep an eye on it and monitor things for changes.
Okay, sure. Well, thanks, Scott, for sharing your insights on this important topic. That's it for today's Navigating Taxes update. If you have any questions or want help evaluating your Nexus risk, reach out. We're here to help.
I'm Scott Brody. Stay compliant, stay confident.